go ahead and get started now. If we might have some more stragglers trickling in, but this is a little bit impromptu, given that this is our first in-person seminar in maybe since 2019, from what I've been told. So it's a pleasure to see some people in person and to also be able to have this experience in person. But for those of you who are joining us online, we are very, very happy to welcome, and we have some more people coming in, I can hear now. So please do let me know, by the way, if any of this is not coming through, if anyone needs to raise the volume or anything, I'll be behind the laptop. But it is our absolute pleasure to welcome Professor Nicholas Karn from the University of Southampton, to come speak to us today about pleas and adversarialism for the common law. So we have a PowerPoint that was circulated via our email, and those of you in the audience will have a handout with the same content, and we will go ahead and get started. So,
fine, brilliant, thank you. The talk I'm going to give today is in two parts. The first part is essentially something of a preface, which explains something about the methodologies and approaches that have been used in relation to law before the common law era. So I'll run through some observations there about how some of those approaches have shaped our understanding. When I've done that, I'll go on to the second and larger part, where the handout that I've distributed will be quite useful, because then we look at some examples of how people have interpreted particular legal procedures and legal structures, and how we might try to come towards some new methods and some new ideas for understanding and also for linking some well-known and some not so well-known materials. So I'll start off then with my first section on approaches. And what I'm going to talk about is really quite a basic problem. And it's something that we can see in legal history, but we can also see similar things happening in many other historical topics. This is that where we have a particularly clear model for how something works, it tends to attract to it things around it or things that could be related to it, which perhaps are somewhat outside the model itself, so that there's a danger of sort of a particular model creeping outwards. In relation to legal history in the Middle Ages, this danger is particularly strong, because in this case we have the common law. Now, in the form in which this appears from the late 12th century and really develops massively in the 13th, this is a really strong structure. The documentation is abundant and fairly clear. The kind of features that characterize it were defined well at a very early date, and they've been recognized very clearly ever since. So there are things that we can talk about the nature of authority, the way the custom is defined, the center versus periphery dynamic, the authority of kings being brought into it, the role of justices, lawyers, the centrality of property law, and the particular practices around process that we can see in the early common law. It's a particularly compelling model because it also matches a lot of modern perceptions about how law should work. There's a sense here in which law and culture inform each other in terms of how we try to understand the role of law in past societies. Where our problem is that where we have this common law model that's really well defined, how do we try to make sense of that in relation to periods where many of the fundamentals on which it depends are not in place? And a lot of recent research has tended to undermine how far we see many of those common law fundamentals stretching back into the past. I think the works of people like Paul Hyams and Tom Lambert are particularly important here. So this problem especially applies to the 11th and 12th centuries. So these are before the common law is in place, but at the same time we don't have all the kinds of texts that document the pre-conquest legal system and which peter out in the time of Canute. So in that sense, we don't have big programmatic texts that tell us what's going on. Instead, we have a lot of material but it's quite diffuse, and it's often not been organised especially well. There are also some quite significant gaps in scholarship, so that some major texts have not really received modern critical attention in the way that many earlier ones have. And I think that what this tends to mean is that sort of in-between bit, the 11th and 12th centuries, are particularly hard to understand and define in terms of legal history. And many of the approaches we take to it tend to try to assimilate it to more powerful structures around. What I think what we're trying to do is to try to reconstruct and to try to recognise some of the otherness of that legal system, and where there are things that are going on there that run counter to, or which are very different from what we might see at a slightly later date. There are also other things going on in that period that are particularly worthy of attention, and I think one of the major gaps here really is looking at the question of land. That often looking at land cases in this period is assimilated towards later ideas of property. At the same time, the earlier material, the Anglo-Saxon texts, tend not to talk about how exactly we might want to try to think about the ways in which land cases could actually be resolved. So in a sense, we have their problem. We've got quite a lot of cases, but we don't really have much in the terms of legislative texts or even reflected texts that tell us what's going on and what are the words and categories that we need to organise this massive material. So that means that even sort of within the period I'm talking about, there are marked differences in terms of what things are knowable. The kind of social order cases have attracted much more attention because we do have the pre-conquest texts, and because there are many things going on there that are very different. Things such as tithing or deal and soak don't fit into a lot of later legal practice. So I think that looking at how land cases are done in this period, we see some marked problems. We can see the attempt to push backwards common law ideas, and this often means that sort of land is reified in terms of property, which often has some quite limiting effects upon our understanding. And often there's an attempt to find quasi-justice figures that would bear royal authority into this kind of period. There's also, for this period, a major problem with the evidence. And this is something which is quite fundamental, and where I think there is a large gap in research. If you look at the later common law era, there are central texts that we can use to try to understand what's going on, and these are fundamental to all kinds of medieval legal research. Things such as the Curia Regis rolls, the various central law courts at Westminster, but also for the 13th century, the very large body of eyre rolls. So we have all these kinds of things that represent the viewpoints of people within the system, but have a huge advantage of noting down lots of legal instances and cases in quite standardized terms, so that we can to some extent understand how it is that these people were actually approaching it. Clearly those texts are not unproblematic, because we can see cases where there's well-documented jury refusal, even in the 13th century. This is where the law is pushing a case in a particular direction, and the justices are pushing hard towards it, but where juries just say, no, we're not going to go there and convict. So clearly we can see there are variable ideas. There's a dialogue there, and not everyone agrees with the same basic ideas about how law should actually be run. But before the 1190s, we don't have any of these records. Instead, what we've got are descriptions of legal cases, narratives that are prepared by participants. And I think the significance of that needs to be emphasised many times, because that has to change how we read these things. We can't treat them as being in any way comparable to the later kinds of legal records. And in many ways, it's quite obvious why they're different. They're not trying to record cases in terms of thinking about what are the consequences, like the royal records are. They're not trying to note who gets fines or who should be treated in particular ways. Instead, they're representing individual, institutional, often quite idiosyncratic responses to what's going on. They're frequently picking out of legal process the bits that interest them and the bits that seem best to support however they thought about their own interests. And this means that we do have something of a problem in terms of understanding what's actually going on in many of these cases. And this is where I'd like us to turn for the first time to look at one of the texts I distributed for discussion. So you'll see there were two short paragraphs. One is labelled Extract from the Evesham Abbey narrative, the other one Extract from the Worcester Cathedral narrative. So both these are drawn from narratives and chronicles written in these two great churches. What's significant about these is that they're describing the same body of legal proceedings. But what's interesting is how differently they perceive it. So that even though they're talking about the same session, the same meetings at the same point in time, they're understanding them in very different ways. They are putting the interests of their churches and the particular claims to bits of land that were involved there at the centre of this. So that we can see each is giving what's essentially a highly selective narrative that only focuses on a few things that mattered to that particular church. They've also written at slightly different times. The Evesham one, it's based on a narrative made by the then prior Evesham Abbey at about the time, but it only survives in an edited version produced by the then abbot in the early 13th century. Meanwhile, the Worcester one goes back much closer in time to the events that are actually described. So I think it's sort of quite interesting that in these, Evesham essentially writes out Worcester and sees that particular clash as being not what's relevant here. This is Evesham's tenants rebelling against the abbey, and the evil, rapacious Bishop Odo stepping in to try to exploit that situation. Meanwhile, Worcester perceives it as much more a Worcester versus Evesham clash, and that's a feud between these two big churches quite close together that goes on over a very long period in time. So we have to bear things like this in mind when we're trying to talk a bit about how we understand legal cases in this period. We don't have consistent law records. We don't have many books about law. We're trying to modify it or explain how it works. We need to work from these quite slippery kinds of narrative sources as usually our main body of material. This, in a sense, is something that applies to a lot of the cases that we're trying to work with for the 11th and 12th centuries. So trying to work out what's going on is something we have to do quite subtly, because we have to reflect a great deal on what exactly in these kinds of narratives are we actually looking for. And this is where the approach we're taking is something which we have to use, and also be aware of the limitations of what it is that we're actually trying to apply. So with that in mind, I'm going to move on to part 2 of this talk. And what I'm going to try to do is to pick out and explain some of the key legal pleas from this period, and try to understand them in a very non-common law way, and to try to pick out of them things that are consistent and which turn up in lots of pleas, but which haven't really received that much historiographical attention. And for this, I'd like to look at the table. So this is sort of pages 2 and 3 of the handout, or I put extracts from it on a couple of slides in the middle of the PowerPoint. And what the table does is that it tries to show some of the features that characterize some of the major well-recorded pleas, reaching back into the 10th century and running on towards the middle of the 12th. And it's inspired very much by thinking about what we see in the narratives and what are the things in there that writers and describers of legal pleas are picking up on, but which don't necessarily seem to fit into the kind of institutional or interest-based approach that we see. So to pick up on things which are essentially, I suppose, incidental to the narratives themselves. So if we think a bit about the Evesham and Worcester cases earlier, one thing that stands out with those is that it notes that this is a very big and unusual meeting that it's being transacted at. So toward the end of the paragraph there, you can see that it talks about the evil men of 5 shires, which have been gathered together in order to hear this particular plea. This is something which, in terms of our earlier Anglo-Saxon material or our later common law materials, is very hard to explain. Why would you want to gather 5 shires to hear a particular kind of plea? What is going on here? And these kinds of references, where we see the presence of multiple courts and multiple legal bodies and gatherings, is something that we can trace through quite a lot of the major legal pleas from the 10th to the 12th century. And in a sense, the table presents an overview of that. I think that this table is in many ways something of an underestimate, because you'll see the right-hand column mention the source on which it's drawn. For this purpose, I've restricted myself to just a few major sources which describe pleas in this period. So Patrick Wormald's old list of Anglo-Saxon lawsuits, Susan Kelly's recent edition of the extensive legal text surviving in Charterholm from Peterborough, and also Van Koenigham's English royal lawsuits. This is something that only draws on those for the sake of clarity, but I think that there's quite a bit more material isn't represented in those particular kinds of collections. And I think that sort of it's well to focus on sort of how this has been drawn up. In this, I've only included those cases where we've got a very specific mention of there being multiple units present. So either it says there are the men of a few named shires, or that there's a gathering of 5 shires, as we saw in the Evesham dispute. I've excluded from this some marginal cases. So there's quite a few hundreds that always meet as a pair, as a double hundred. I've excluded those cases entirely from this table. So, for instance, in terms of double hundreds, in the 11th century, the whole of the Isle of Ely, just north of here, was one large double hundred, the double hundred of Wychford. So it meets at the village of Wychford, which is a bit west of Ely, and it transacts most of the legal business coming out of that particular district. It's always described as a double hundred because it's quite big and seemingly has a fairly substantial population. But even though it's classified as a double hundred, the 200 aren't really separated out for doing business until much later, when sort of parts of its jurisdiction are separated away. So I've excluded cases like that. I've also excluded as the one similar case that applies at the level of counties. So the county courts of Derby and Nottingham meet together up until the 1170s. because there are quite local reasons why they always meet as a pair, I put those on one side as well. I've also excluded the quite numerous pleas which state that they were heard by people coming from very wide districts or from across the country as a whole. And we don't really know what's going on there. It might represent a gathering of multiple shires like this, or it might represent a meeting of the King's Court. The table presents, as you can see, the date of the meeting itself, a brief description of what the units are and what the kind of business being transacted, notes about location, about who the eminent attendee figures mentioned are, and finally what the source itself is. So this is, in a sense, a very conservative table. This only represents cases where we can see this sort of multi-shire thing or multi-hundred thing going on in fairly sort of clear terms. I've filtered out the more ambiguous cases, but they would about double the length of this table. And I think that if we look at the details of it, what we can see here is something that shows how this is operating over quite extended periods. So it starts off where we've got a few cases which are concerned with the refoundation of great abbeys in the middle of the 10th century. The story of this has been set up many times, and it's a well-known one. That we have King Edgar and Bishop Ethelwold of Winchester put significant resources into buying back the sites and former estates of great abbeys, many of which had been damaged or indeed entirely destroyed before that. When they do so, they do so with the idea that they're introducing newer forms of monasticism, so that they're putting those churches under the Benedictine rule rather than the looser rules that often were in place. These kinds of developments often resulted in major disturbance to local patterns of landholding, so that many of these result in long-running litigation and widespread criticism. So that's the kind of thing why some of those early cases are showing up, because those turn up, written up in chronicles that describe the interests and doings of some of these great abbeys. So the cases there come from Abingdon and also from Ely, both of which produced significant chronicles of this period. The middle section, you can see that all comes from Peterborough. Now these were not included in Patrick Roman's list. That's because these represent land transactions, land sales, land transfers, not disputes as such. So his list of Anglo-Saxon lawsuits excludes this. It's worth noting that there are lots of things that don't make it into his list. We could do a much bigger version than he attempted. And in this case, the monks of Peterborough produced a long list in which they set out what are many of the lands they'd acquired, and also what's the basis for doing so. They didn't have charters that documented their possession of lands. Instead, they produced this item which lists how it was transferred to them and who were the sureties that did so. And this repeatedly occurs before multiple hundreds, often before big gatherings of them. You can see one of the cases, 971, which is 1, 2, 3, 4, which is the fifth one down, is before 800s. So this happened at Oundle in Northamptonshire, and that must represent about half the county. So that's a really significant meeting, and it's something that doesn't normally take place. So in that case, we have to think a bit about what's actually going on here. Why are they gathering such large bodies of people together to try to witness and manage transfers in property? Because it's so much outside later experience that, in a sense, we need to try to explain it. So you can see that there's a lot of 10th century activity from Peterborough there, but then we have a hiatus. And in a sense, I'm not sure quite what to do with that. But clearly from the 990s up until the 1070s, we don't have similar comparable cases noted. I'm not sure how significant this is, because partly we could say that this is showing that there's not much going on, but it's also worth noting that we don't really have that many clear legal narratives from this period. So this may be a case where the pattern of sources is what's structuring our approach to it. And the fact that from that first half of the 11th century is not a rich period in source material is what's giving us this gap. I mentioned that I have more cases that are ambiguous to this. I do have a couple of instances where we've got a case in this period which is kind of a marginal one. There's a nice one from 1030-ish in Canute's reign, but a plea in Hereford that sort of implies there's a lot of people there and that the king sent a representative, but it doesn't actually specifically say we have multiple counties present. So there are ambiguous cases in that gap that we might use to try to fill it against. But what we can see reading on through this is how there's then a major surge in this after the conquest. We need again to say, what does this mean? Does this indicate that this is an old procedure that's being revived? Or is it just that the fact that there were so many major pleas post-conquest in which individuals and churches are trying to sort out the mess created by the aftermath of the Norman conquest? And so we do have major pleas where there were big stakes, where the amount of land that could be taken away from someone or given was really very, very large. So many of these pleas relate to the work of, and assets and interests of great churches, and they record how they defended them, or in some cases failed to do so. What's notable for these as well is that all this landscape of sort of change and threat generates a lot of historical writing. The significance of this sudden uptick in writing has been noted for decades, and I wonder how far that's driving some of the patterns we can see in this table. That suddenly there are dramatic events to recount, but also there are difficult events to be recounted. And so what they're trying to do is sort of to tell future generations of clergymen or monks that this is how we dealt with it. And these are the kinds of ideas and tactics and strategies that might be useful in the future to deal with similar problems. But we can see there, just to run through the list a bit quickly, we've got the Pennant and Heath pleas, in which many of the assets of Canterbury Cathedral and the House of Monks attached to it are debated in relation to seizures made by specific Normans. We've got the litigation over the bishopric of East Anglia, whether the then bishop could take over Bury St Edmunds Abbey to form a more suitable seat for his bishopric. We can see the Evesham and Worcester grudge match that goes on and on for a long time. Worcester's pleas against the sheriff to try to defend its jurisdictions around the city of Worcester itself. Worcester is very well recorded in this period anyway. So the fact that we've got so many pleas coming from it that have Worcester connections is telling us that there's something documentary going on here. But also we've got the many Ely land pleas, and this is a series which is documented partly in Ely's narratives, but also from charters and other things that survive through it. So we can see all of those exciting cases, and those have often attracted a great deal of attention. For something like Pennant and Heath has been brought into discussion to try to explain how many of the legal doctrines around the conquest and around legitimate possession of land in the aftermath of the conquest were actually defined. So if we can add readings to what's going on there, that's a significant gain in understanding. To move onwards from this, we can see there's a few cases mentioned very briefly in Domesday Book, but also then we can move on into the 12th century. And I think that these are very significant because they've never really been brought into relationship with the earlier examples. That while we've got discussions of the Pennant and Heath case, which related to the Ely land pleas, let's say, there isn't that much attempt to try to contextualise that more and link the processes we can see there to later kinds of legal plea. But you can see there that there's quite a few cases post 1100 that discuss where we have quite big meetings, multiple counties, or indeed multiple hundreds that are brought together to try to cure particular bits of business. And again, it's often quite complex ones. So you can see there's a couple there about the relationship between the county of Northumberland and the sheriff of Northumberland versus the interests of the Bishop of Durham. Because County Durham originates essentially as a privileged liberty within Northumberland, and trying to set the limits on that, what rights do the different parties have, is something that takes a very long time. And they only really achieve a stable solution to that problem in the 1190s, when Richard I is financially embarrassed and then Bishop of Durham buys lots of rights from him. So we can see there sort of a difficult case with big implications. We can also see other things that are quite complicated. Under 1127, you can see that there's another case concerning the major churches in Kent. This again is a long-running dispute. It goes back to the time of King Canute, and it's over the relevant and relative rights of Christ Church Canterbury, that is Canterbury Cathedral, versus St Augustine's Canterbury over the two parts of the port of Sandwich. Sandwich is a really lucrative port, and the two sides forged documents quite extensively to try to get one over on the other side. But this is heard by a big gathering at Sandwich itself, which draws in quite a lot of people from across East Kent. We can also see as the end of this list, 1133. That's the latest example I've been able to find. And this again is kind of big business. Because in a sense, this is a continuation of the earlier Ely land pleas. What's going on here is that there's a new Bishop of Ely has been put in. He's concerned that his predecessor has been too free in tolerating occupations and also in giving away lands to his nephews and relatives. So he arranges for there to be major investigations held into who actually has the right to have all of this. And it's held at Wandlebury, which is a former Iron Age hill fort a bit south of here. I think it's interesting that it's 900s. He doesn't try to run this through the county court at Cambridge itself. Clearly, he's trying to achieve something by running it through this route, not by using one of the more conventional methods for trying to resolve this stuff. I mentioned that 1133 is the latest example for this, and that's on the basis of a fairly thorough investigation. So there are plenty of later cases where sort of double hundreds meet. That's fine. But if you look at the very extensive collected pleas of Henry II's reign, or indeed from Stephen's, we don't see anything like this kind of process. So I think that 1133 represents possibly a quite significant cut-off, that things were different afterwards. We can try to explain this in many different ways. Perhaps we could say it's King Stephen's reign after 1135. There's a civil war. King Stephen loses control of great swathes of the country. When Henry II returns, he's much more interested not in bringing courts together, but in introducing the early parts of the heir system, which you have travelling justices investigating the country. So I can speculate a bit that there's something in those areas that might explain this change. But even so, I think that I would have to admit that what I'm saying there is essentially speculation based upon the pattern of evidence that I put in this particular table. There's quite a bit there then that points to how there are things in legal pleas from this pre-common law phase, where actually we've not really investigated the narratives to try to pull out what's going on. And we can identify things that are potentially very significant, that don't really have any representation in the literature on these kinds of matters. And of course, that leaves us with many problems. We don't have we don't have much relevant legislation from the kings in this period trying to explain what this means. None of these name a word that we could use to describe it. They'll often say the men of so many shires attended this plea, but they never really use a nice word that we can use to label it. And that, I think, is more because of the lack of legislative texts in this particular period. In a sense, we need to try to think about naming them in order to make this look more substantive. But what we do have, and what we can use, is that there are some things that we can link with this. So this comes in sort of the last page of the handout, or in the final, I think, 3 slides on the PowerPoint. And the first couple of things I put there are some brief extracts from the source known as the Leges Henrici Primi, the laws of Henry I. Now, this is a complicated text, and in many ways it's not received the attention it deserves. What it is it's an attempt to write how law should be done at the level of the 100, and it's written in about 1108, 1109. It's a difficult text. It survives in heavily interpolated versions, but it's one which is potentially of huge significance as a non-authoritative, but nevertheless a quite sort of weighty piece which describes how law could be done and how it could be managed in this period. I think as a text, it deserves a great deal more study and investigation than it's received. But what I wanted to draw your attention to here is how there are things in it that link with the terms I've just been talking about. So if we look at the first of those extracts, which is the Leges chapter 31, you can see there how it talks about 100 or county may be judged by 2. So it's allowing for the possibility that you might want groups of courts meeting together. So it directly connects with the kind of terms in the table I presented earlier. It also sort of outlines to us some rules for how this should be done. That it's actually the number that matters. That it's not possible for one county to judge multiple ones. So presumably we need multiple counties to judge another county. Also, we're talking here about judgment. Why are they trying to judge counties and hundreds? Why are they trying to make them some of the participants in cases? And is that what's going on in the cases mentioned in the table? If Evesham and Worcester think it's all about them, is this actually not how it would have looked to other contemporaries that weren't obsessed with Evesham and Worcester? So this sort of takes us back to our earlier point about how the way in which our pleas are written and structured can help to hide a lot of what's going on and actually reduce our sense of how big some of these pleas are. They might have lots and lots of participants, or with particular interests, which are coming together as part of this. So Leges Henrici Primi, chapter 31, is therefore quite a significant item, and it's not really been discussed very much, but it relates very closely to the terms I've picked out of the pleas. I'd now like us to look at the second of the extracts. So this is chapter 7.5 to 7.6. So this is something that is drawn out of a long section that is about one of the big themes of the Leges Henrici Primi. So there's a lot of ink used up early on to talk about how judges have to be responsible. They need to be, in modern term, ethical. They need to hear the participants and engage with what they're saying. They need not to be bribed or anything like that. So it talks about then kind of how responsible judges need to be. There's quite a lot going on in there because it does stress how it is about judges, and before the common law, before royal justices are there, judges is the usual term used to describe the people who attend these court assemblies. So that means anyone of sort of status, of who had a certain age or seniority, and a certain level of respect and wealth within the community, and so was kind of empowered with other people of similar position to make judgments that came up before the court. Remember, these are very participative, assembly-like institutions. But I think what's worth stressing here is that it's making the point that if the law is not run properly, if proper process, if sort of proper procedures are not followed, then actually they kind of lose the case. So that it should go to a different setting. If there aren't enough judges present, if they're sort of lacking in numbers or in wealth, that this is actually a significant problem. So this system is one where how the court's operating is being watched. How it's possible to move cases from one type of court to another, as the conduct of the case seems to make it necessary. My third extract from the Legate Henrici Primi, this is chapter 34, part 1. I just put that in there to make the point that there are consequences for this. So that if judges and others mismanage cases, if through anger or hatred or fear or love or greed, they don't act responsibly, they follow the politics of the case maybe, rather than who actually is in the right, then they are figures who are disfavoured and they are fined for it. So how cases are conducted is a big deal, and those who have the responsibility to conduct them but don't do it properly are a bit of a problem. And I think that sense that we can sort of use other courts to supervise courts when they're doing business is quite an interesting one, because in a sense that's later what kings use justices to do. At this point in Henry I's reign, they don't have justices yet. The figures called justices in Henry I's reign are more like coroners, and they are trying to collect business in the king's interest and manage cases for his profits. The aim of it is something that's really very, very, very different. But I think that idea that courts could be judged in terms of how they're doing things comes out of this fairly clearly, and that other courts would kind of be the jury in this case to sort of hear what's going on is quite an interesting model. So I wonder how far this we can connect with the earlier points that I'd mentioned there. We can also link it with much broader concerns. Well, since the work of Patrick World, we've all been very aware that it's Christian kingship that lies behind a lot of this. The idea that the king has a responsibility to oversee justice, to ensure that it's fair, and so on and so forth. And that this is kind of sort of a big animating principle is really an important one. And in many ways, we can see in some of these things described in the Legate Henrici Primi, attempts to make real those kinds of responsibilities. We can also see some of the same thing taking place in our Doomsday Book. And there's quite a lot of similar cases in the Doomsday, so I've just put two for you there. Both of these concern cases in East Anglia, where Little Doomsday Book is a bit fuller than Great Doomsday Book for the rest of the country. But what I put those in to show is just to make the point that the decisions rendered by hundreds are repeatedly shown in Doomsday Book to be, I suppose, things that people would regard as being questionable, so that they are willing to offer a judgment process as a means of refuting it. So that means they're offering the ordeal or trial by battle as a means of trying to sort of trump the hundred's judgment. So they're trying to essentially bring a judgment to bear upon a case where the testimony of the jurors and the judges in the hundred itself is presumably more or less unanimous. So this again is pointing to kinds of debates around existing cases. So those in a sense are quite sort of tricky to introduce here, because they're often talking about really very local rivalries and enmities that are often quite lost to us. But nevertheless, they're pointing to how people could talk about these sorts of judgments. And I think it's that sort of sense of how they talk about it is what I'd like us to see as being one of the main items there. So I think that sense that what these might be about is how justice is being done is an idea that I'd like to introduce, maybe an explanation for what's going on. There is one that we can point to as being a really clear case for this one. So it's the one at the top of page 3, the case involving Rochester is an excellent example of this. What has happened in this case is that at a place called Ilam, which is not very far from here, just on the border with Suffolk, Rochester had a long-standing claim to land. However, the then sheriff of Cambridge coveted that land. And so what he did was he used his position as sheriff and all that that brought with it to try to get the people who were making judgments in this case to return a false verdict in favour of him as sheriff. What this narrative describes, and it describes it very much from Rochester's perspective, is how the judges in the hundred that had heard this case at Ilam were exposed and were then investigated and punished and were taken out of their area to do so. So the later stages of this, they're not done locally within Cambridgeshire, but they're taken to London for this to happen. So clearly at one level, the narrative is Rochester-centric. Rochester looks like it loses, but then its enemies have a horrible comeuppance, ha ha ha. So that's sort of the tone of this thing. But it does point to how this question of judgment and how it's done is actually central to this. What's remarkable about this story is that it's the judges who return the false verdict who are the ones who are followed up. We're not told that the sheriff suffers horrible consequences for this. Clearly, in some sense, it's they who are the real villains here, not necessarily the one who was involved in actually bribing them and intimidating them in the first place. So I think that the Ilam case is something which might sort of lead us further to link these Legates Henrici previous passages with all the cases that I've mentioned in the table there. Fine. So I think then what I should probably do is to think a bit about what all of this means. Because I've dumped a lot of information on you in the recent past. I've talked you through a lot of pleas and different kinds of source about how law is done from the 10th century onwards into the 12th. But what I think the big lessons I sort of take away from this are that in many ways, law in this period still holds really significant mysteries. Because we lack that sort of body of royal text to control our understanding of it, there's a great deal at stake here, and also a great deal that's potentially contested, because so many of the sources from this period have been perhaps less fully looked at than those from a century or two earlier. So I think there is therefore quite a big research agenda here in terms of trying to understand what's going on. I think also it's significant that it's got to be the narratives that are the major source for thinking about this, because they are slippery and they are things which represent the interests of institutions and individuals, but they are relatively rich sources and talk a lot about how people relate to each other in these settings. So what they're talking about is about what we could call the dynamics of pleas. Who is actually trying to get at whom? And often what they're doing is suggesting that these pleas are much bigger than just someone suing someone else. Often they are there are multiple parties that are involved in them to a greater or lesser extent. And in a sense, it's a challenge for us to think about how we can integrate the work and the interests of those different groups. And I suppose that takes us on to a word I'd introduced earlier. I talked about how something I think we need to talk about more is the otherness of law in this period. That they're often doing things that are very alien compared to sort of common law assumptions. And I think a lot of the literature on this has tended to try to assimilate it to later norms, not so much try to establish what's actually distinctive. So while I think this is a moderately clear case, I think there's a lot more stuff going on in the pleas from this period that we ought to be able to reconstruct, to think about what law means, but also about many of the social relations that are encoded in that law. I think that the idea of these multi-court meetings is potentially a really important identification, although I'd be interested to hear your responses to it, because it does have quite big implications for how we read these cases. And when some of these are things such as Pennant and Heath, which is quite central to how we think about how legitimacy in land ownership is reformulated after the conquest, that's got to be quite a significant step forward. I think also that looking at this helps us to think about how some of these well-known cases like Pennant and Heath are maybe much less exceptional than we've tended to approach them in the past. That they let us recontextualize what they mean, and think a bit about what the parties involved are trying to get out of them. So I think in that case, those themes around otherness are kind of what I would like to leave you with as, I suppose, the main sort of takeaway from this particular session. But I'd be very interested to hear your thoughts on what this multi-court business means and how we can best understand what's going on here and what it all means.
Thank you so much. That was absolutely fantastic. Do we want to start with, and we have some applause in the online audience as well, figure out how to turn this around. Do we want to start with any questions in the room before we go to our online audience? Well, while people are thinking, I have probably will expose my ignorance, but a bit of a question related to the sources themselves. You had discussed how there would be attempts to question or trump the judgments of some of these courts. Could the actual sources, the recordations of some of the litigants being involved have been recorded with the idea of being used in the future to challenge the decisions? Would that possibly be reflected in any of the sources?
Well, reputation is really very important in terms of how lots of different kinds of legal business is done. So, for instance, if someone is accused of theft or some kind of sort of personal injury, then kind of what their reputation in the community is, whether they've been accused of this kind of stuff before, that's quite central to how those sorts of cases are handled. And we get this out of the pre-conquest royal legislation. I suppose. So in that case, yes, reputation is central. It's absolutely vital. The question I can't answer, though, is how far that spreads. When we're talking about things like this that are a bit less personal, in a sense, where we're talking about the sort of the estates and lands of great lords who perhaps never really go there, and where it's their agents who are more important, or where we're talking about the interests of big churches that are by necessity institutions which aren't individuals. So I suppose how far reputation might affect those is something that I can't really answer. But the earlier sources do strongly indicate that yes, reputation is absolutely central to this. What the community thinks of someone is absolutely vital criteria. Yes.
And just to follow up on that question, is there any indication that in cases of multiple courts that reputation might have advantaged one over another in the choice of courts that might be involved, or in some kind of, because one of the things that really stood out to me seems to be somewhat of a lack of a hierarchical structure in this, given the kind of impromptu nature of bringing these courts together. I shouldn't say impromptu, but I'm just kind of curious about what the implications of having these different entities involved in the judgment process being at the same level conceptually might be.
Yes, that's an excellent question, and it's one that I would struggle to answer, because we are sort of dependent on the narratives and the limitations of them, and they tend to describe stuff that happens. They're not so good at rationalising what's actually going on. So I think the last of the cases I discussed, those pleas at Wanderley, why is a really difficult question there? Because clearly the new Bishop of Ely, he has a problem with what his predecessor had done, in the sense that lands belonging to his church have been taken away. But why he goes about it this way, I have no idea. Why didn't he do this in the County Court for Cambridge, that would have had a kind of jurisdiction over it? Why does he take, I think, is it eight or 900s to do this? Cambridge would have had, I think, 1400s in this period. So he isn't taking the whole county, but most of it. Why? At one level, you can say he can do this because he is well connected to court, so he can presumably get writs from Henry I to say that he wants to get this business dealt with, and so this is how he wants to proceed. But what his reasoning process in doing this goes way beyond the sources as they survive. So so I think we can infer a certain amount. We can sort of try to think our way into the position of some of these people and rationalise their decisions. Or even if we don't rationalise their decisions, at least we can sort of establish what are the range of possible decisions and outcomes. But I'm afraid we can't really go much further than that.
Makes a lot of sense. Do we have any?
Can you ask, is this emphasis on misconduct by judges possibly significant in that it keeps recurring, and it sort of feeds into the early common law notion of false judgment, which, as Professor Wilson has shown, is different from error as it later becomes, which is error of law.
Yes.
It means the judges have misbehaved.
Yes.
And if what you don't see is any suggestion that the judges misbehaved because they've applied the wrong rules of law.
Indeed.
So doesn't that rather suggest that they aren't really thinking of rules of law as we would know? But it is more like I was going to say royal commission, but without the royal. It's a sort of administrative exercise in looking into something, big investigation. Let's get witnesses and see whether they behave rightly or make recommendations.
Yes.
So that's not law as we would understand it.
Yes. Yes.
They would understand it in 1200 probably.
Yes, I think that's sort of very much the right approach here. And I think that case about Ireland is something that fits in exactly with what you've just said there. That is the people who from the 100 who were the judges in that case who gave testimony to this. They're not being accused of not understanding the law. Instead, what they're being accused of is rendering false witness, essentially. So that they stated the sheriff has a strong claim here, he's the rightful occupant of the land, and ignored Rochester's older claim. So it is sort of errors of fact in that case, in terms of how they describe what had been in place in the past. That's sort of very much what they're being challenged for. And if we think about who they are, that makes complete sense. They are the people from the 100 who have wealth, who have status, who have seniority, and they have authority because of those attributes. They're meant to know sort of who their neighbours are, to know who has sold land or transferred land to someone else. So while they call them judges, they're almost as much a kind of standing panel of witnesses to actually see what's going on locally and use their prestige to validate it. And I suppose the point about the island case is that they failed to carry out those functions.
We have one question that's just come in from our online audience, not to neglect any that may have come in behind me, and I apologize for my orientation here and not being able to see too well. It is interesting that Henry I thought it important to set down that a 100 or county court could only, with a question mark, be judged by 2 or more. Are there cases where a sole 100 county purported to judge another or 2 others with less than satisfactory results?
The situation that's flagged up in the Legate Henrici Primi, whereby one court might try to judge multiple ones, I've not found an example of it. So while clearly the writer of it thought that this might happen, and so it needed to be flagged up as a problem, we can say that's definitely true. We might try to infer and say that the writer had encountered a similar case, and so was keen to say that this had a bad outcome and we should never do this again. But I can't really point to specific cases where we can see exactly that going on. All the ones that I put into the table there, which are those where we've got a reasonably clear sense of what's going on, are ones where we've got multiple shires gathered together, and clearly the problem is in one. There is one case that I didn't put here. It's from the late 1120s, and it's about sort of fishing rights and the county boundary between Surrey and Middlesex. And I didn't put it in because the case just said that it was men from all over England who had judged this case, not specifically a certain number of county courts. But I suppose that sort of might be a case of where we've got sort of essentially 2 counties being judged at the same time for what's going on. But I suppose that's the most elaborate case I've got that might fit into this kind of thing.
We've had another question come in, and if you would like to turn on your camera to ask that way, I'm happy to turn my laptop here. Perfect. There we go. So please.
Hello. Right, I have lots of questions. That was a fantastic paper. Thank you. The one I want to ask is about the eminent attendees and presiding figures. For many of the cases that you don't list anyone. And I just wanted to, I wanted to ask you what you see their role is in these larger assemblies. Are they fundamental to what's going on, or are they kind of sort of unnecessary appendages?
Okay, that's well, I'll just repeat the question for everyone in the room. It was asking what's the significance of the eminent attendees? What do they actually do, and are they vital to the functioning of these kinds of bodies? And clearly that picks up on the fact that I did include them in the table there. I think there's a couple of things going on here. I put that table there, that sort of element in the table rather, because I think that that's what the narratives are telling us. That frequently they will say that we have a meeting of multiple courts and assemblies, and it will name 1 or 2 eminent individuals who are present. So clearly this is something that the writers of narratives are flagging up as being, this is significant. So that's why I put that in there. In quite a few of these cases, especially going back a couple of decades, an argument has been put up that these figures are essentially sort of proto-royal justices. I'm pretty sure that's definitely not what's going on here. And the reason for this is that essentially they don't really do anything. even though they're present, they lend their dignity to the occasion, they're not taking a very active part in the proceedings themselves. So they're, the one which is most specific here is the 1127 case in Kent, where we have this dispute between the two great churches in Canterbury over rights in Sandwich. And in this case, we're told that sort of William, Sheriff of Kent, was the sort of senior figure present, and he is the one who's sort of ordered to sort of make sure that this event is happening. So he's ordered to sort of gather the peoples together, to summon them. But once we get into it, he's there, and he's clearly being dignified in his particular way. But he doesn't really do or say anything. He isn't questioning the people. He isn't trying to sort of push procedure on in particular ways. He's a figure there who's perhaps behind the organisation of it, but kind of letting the procedure take place as the participants want to, and he is there to represent royal authority and dignity. So I'm not entirely sure what many of these figures are doing. But I think it's interesting that we do have eminent figures who are flagged up as being important, that in most cases they are figures who have royal favour, and that they have strong connections at court, and are figures who are trusted by kings to do stuff in many settings. So in that sense, I suppose I'm kind of going to duck Tom's question a bit, because I think the sources don't let us go far enough to explain what all these figures did, although they are telling us that they were considered very significant at the time. Though those sort of once proceedings start, it's their silence is more sort of noticeable than actually doing anything very practical.
Yes, please.
Thank you so much, Rachel. Off of that and the existence of these proto-royal justices, and this made me think about your book a lot, and that you're arguing that maybe under Henry I we do have more of these presence in courts, but as you said today, kind of at more of a passive level, looking out for the king's business. But back to what we were talking about, judge misconduct, and I'm quite interested in who's enforcing that, and how that we talk about, paying fines to the king. So presumably there's some kind of king's representative. Do we think that it is these same people, and this is kind of one of those passive pieces of king's business that they're waiting to see pop up, and then now you're going to pay a fine to the king?
Yes. I think that's entirely plausible in terms of what's going on here, that they are sort of observers who could turn into accusers, presumably, as far as particular bits of business developed. I think that's sort of entirely plausible, and it kind of fits with something like the Ireland plea, which is sort of our clearest case in terms of how this is actually exposed. I think they probably don't have the power to sort of just say, you did it wrong, I'm fining you lots of money. I think kind of they're more there as accusers to say, we have a problem here and we need to do something about it, and get important people as well. So it's a kind of, I think they don't have sort of enormous authority to do this, but I think that idea that they are there to observe and to sort of deal with problematic behaviour is highly plausible. Yes.
Sorry for missing your question. Anybody else in the audience here? Do we have any other online questions? Oh, yes. I will turn this right back around, and please go ahead.
Me again. So I wanted to ask you about judgment, because this seems like a very good opportunity to ask you what exactly it is that people are judging. What are the decisions that judges get to make? Are they procedural about who gets to swear an oath or to go to an ordeal, or do you think they're making substantive decisions?
I think that when they're proceeding in particular pleas, they don't draw a distinction between testimony and judgment. So this means that when the judges of a particular 100 are hearing some bits of legal business, they're not really making distinguishing or characterizing their role in terms of the kind of structures that we would use. So partly they're bringing information, so that means that they are bringing their knowledge about land ownership, let's say, within their particular district, and they are on the basis of saying that this is my knowledge. That's how they're kind of making decisions to it. Again, I think to drag it back to a particular case is probably helpful here. I think the 1127 sandwich plea is a particularly good one in this case, because it's a kind of whitewashing narrative which is written from the perspective of the monks of Canterbury Cathedral. But what it's saying is that when these proceedings have been started, everyone's put on oath to tell the truth and so on, and then the various judges present, seemingly of their own volition, say that actually it's Christ Church. They have the right in this case. So they're then offering something which is testimony, but in a sense it's also judgment. And what the narrative says is that when they've said this is how it is, that is kind of accepted by acclamation, so that all the other people who perhaps are of lesser authority within that particular meeting then acclaim that judgment as being the thing that is the truth in this case, and what should be the outcome of this particular plea. So in that case, I think because judgment and testimony are collapsed together, we might try to separate them out a little bit procedurally with the idea of acclamation, but in a sense, it's the same people doing it. And so I think sort of collapsing those together is probably the best way forward for that, if that answers your question. Okay, great, good.
Do we have any other online questions or comments? No. Any other in the room or no?
You've opened up this really interesting question for us of in these cases with these kind of strange multi-hundred, multi-county courts, why? And especially, I think you open up with Ely. Why does that happen? I wonder, is there anything to do with the liberty of Ely that they do seem to have a level of autonomy from the sheriff? And did they have increased ability to have a court out of Cambridge? And was that kind of normal practice? I don't know much about. But then in general, do we see that? Do you think that there's an undercurrent of power kind of going on in general that either maybe even secular as well as ecclesiastic kind of barons were seeing when they could keep their control over courts separate from the county courts?
Yes, yes. I think kind of there's sort of two things I'd say to try to answer that question. So Ely is prominent here, and that's because Ely has a particularly strong archive. So we've got the Liber Eliensis, which is a quite rich chronicle, and it's one which is not concerned as its first topic with sort of broader questions about kings and popes. It is quite a locally and regionally focused chronicle. We've also got really strong survival of charter sources and just got sort of minor items from the archive of the Church of Ely. And quite a bit of this relates to churches whose archives have survived. So the same applies to Worcester, which is a really rich archive, and Canterbury Cathedral. Obviously Worcester, Canterbury and Ely all have the advantage that they weren't suppressed by Henry VIII. So in a sense, the archive marches on. So we could say that maybe we might have seen that for less favoured institutions, we would have similar things. It's just their archives haven't survived. Because there are churches which have very privileged situations, they have private jurisdictions, but for this period the surviving material is pretty thin. For Glastonbury, for instance, as the richest of all monastic foundations, the 11th century evidence is actually not very present. So there could be archival things that are going on there. I think to answer the second part of your question, Ely is a very powerful church. It does have claims to run the northern half of Cambridgeshire, the Isle of Ely, which in this period is run as the double hundred of Witchford, and the bishops do clearly have an agenda just to build their control over their lands there. So they're trying to exclude the king and sheriff in various ways. So, for instance, there's some of the earliest people I'm aware of who kind of buy the right to control their night service. So it's no longer sent to Norwich Castle to help protect the king's castle there, but instead it's done locally within the Isle of Ely on the bishop's castle themselves. A number of big churches buy this kind of right out, but Ely is the earliest really clear example for this. So clearly they're trying to say we want to keep outsiders out of the way. I think that this is a part of the broader history of how the idea of liberty and franchise developed, and that I think is another case of a really interesting set of developments, where there hasn't been amazing amounts of recent scholarship on this, and how we assess the way that lords and bishops and others can sort of privatise courts and sort of manage things themselves. I think it's what we see in the early 12th century is sort of part of the story, but I think the second half of the story is how that's sort of extended in the later 12th century, when we got much stronger evidence for lords actually saying, I will buy this 100 or this right, and to get a royal charter that authorises it. And so it becomes a much more substantial thing, not just kind of customary.
Thank you.
Then I had one more as well. I'm not interrupting you, but you had mentioned the role of acclamation in kind of choosing the correct judgments. Could that be related in any way to the selection of hundreds? Might there be a vested interest in which groups might be invited to these proceedings?
Yes, the question of 100 attendance is I think a sort of slightly complex one, because if we go back to sort of the 10th century legislation, so sort of these royal documents that sort of are a first real attempt to sort of set out what hundreds are, then they're kind of making the assumption that sort of all adult free males should be expected to attend these things. Clearly, that doesn't mean everyone's allowed to take part. Who can participate depends upon status and wealth and seniority and all the rest of it. But nevertheless, attendance is kind of sort of possibly quite large. Yeah, and if you think that hundreds are rural districts, they contain multiple villages in modern terms, possibly there's quite a lot of people gathered there. I suppose the story of how this develops is that lords fall into the habit whereby they would send sort of a representative or two from their lands or estates to try to sort of, in a sense, represent the rest of their men, so that membership of the hundred sort of dwindles over time. You still have sort of the big, or the two big yearly meetings where everyone's expected to turn out, but a lot of the regular meetings once every few weeks become much smaller, so they become a kind of committee selected out of the 100, which is probably it's into double figures, but maybe 20, 30 people. Exactly who attends the 100 varies a bit over time. We do have some cases where there are witness lists on sort of settlements made in 100 courts that list all the people there, and that suggests that a sort of representative principle is quite important. It doesn't tend to be the lords themselves who turn up. It's sort of the lay underneath them. It tends to be sort of the priests the skilled people, blacksmiths appear fairly often, for instance, and in a sense they are the ones who are sort of who have, I suppose, a large voice in how these things happen.
Thank you so much. Last call, online or in person? Well, in that case, I just want to say thank you so very much for an absolutely fantastic lecture, seminar. That was very interesting, and I think I speak on behalf of everyone saying we very much enjoyed it, and give another round of applause. Yeah. Oh, never mind. Perfect. Okay. Wait, we might have a hand. Is that Alan? Is that a question or?
Sorry to applaud.
I'm sorry. Is that the wrong button? Sorry, that didn't come through super well. Well, in that case, we'll go ahead and wrap it up, and we will be back in 2 weeks' time. I think it is 2 weeks' time for an online seminar with Russell Sandberg. So thank you so much, everyone.